I would like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land from which I'm speaking today, and to pay my respects to elders across Australia, past and present, and extend that respect to any Aboriginal people watching this premiere tonight. Welcome to the launch event for Volume 43, Issue 4 of the University of New South Wales Law Journal, the fourth and final launch event for the year, rounding off the end of Volume 43 and our work for 2020. We're delighted to be at the Sydney offices of Allens here today, one of our oldest premier sponsors who have supported us now for over 40 years. We're so proud of this long history and relationship, and as a voluntary student editorial board, delivering one of the top legal academic publications in Australia would not be possible without your support. Thank you particularly to Lauren Kay and Tim Stewart, staff partner here at Allens, who will be kindly offering the welcome to the firm today. The launch topic for tonight, the alien and the law, has been informed by a few of the fantastic articles to be published in this issue of the journal. I will leave it to Chan to discuss a bit more of the contents in substance, but wanted to express our gratitude to each and every one of the authors who bring their submissions to us and entrust us to bring your work to publication. To the featured guest for the launch event tonight, the Hon Justice Hammerschlag of the Supreme Court of New South Wales, thank you for sharing your honour's insights and your time on the launch topic. Your kind offering during this undoubtedly busy period is greatly appreciated. To our school in the Faculty of Law at the University of New South Wales, thank you for your unwavering support of our student editorial board's endeavours, continual independence, learning and professional growth. It is a rare and fantastic opportunity to be given the heavy responsibility of steering the faculty's flagship academic publication, and particularly one with such a strong national reputation. It is undoubtedly one of the most valuable academic, social and professional experiences offered at a university level. Thank you in particular to our Acting Dean, Professor Andrew Lynch, and our faculty advisors, Professors Roslyn Dixon and Gary Edmund, for your sage support and advice. Thanks is also owed to Sung Chan Ree, the editor for this issue, for his astounding work ethic, least of all evidenced by undertaking to steward a mind-boggling 16 articles within your issue. I believe it is a record number of articles for at least any iteration of the journal, at least in my institutional memory. Your dedication and wisdom have been an invaluable asset to the journal. As I mentioned previously, this will be the final launch event for Volume 43. I'm immensely grateful for the editorial board, whose hard work and diligent efforts have allowed us to continue meeting the Law Journal's publication schedule despite the turbulence of this year and the advent of a global pandemic. We're so pleased that through the voluntary contributions of time and the flexibility of our board this year, we've been able to put out 4 fantastic issues constituting one outstanding volume. I wanted to also extend my particular gratitude to Sarah Phillipson and Veronica Spesvey, the forum and digital editors, for the entirety of Volume 43 or 2020. Their work is often done from the shadows, keeping the journal running and maintaining the forum, our online short-form publication, which is becoming increasingly important and prescient in this digital age. We're so fortunate to have had your expertise, wisdom and good humour on the board this year, and I personally have been truly lucky to have shared this year of stress, deadlines and successes with you. Without further ado, I will now hand over to Tim Stewart, staff partner at the Sydney offices of our premier sponsor Allens, to welcome us to the firm.
Thanks very much, Antonia. I'd like to welcome you here to Allens for the hosting of this session. We're holding this session today on the land of the Gadigal people of the Eora Nation, and we acknowledge their elders past, present and emerging. And we acknowledge all the elders past, present and emerging of all the land on which we work, live, and their ancestral spirits with gratitude and respect. At Allens, we're very proud to be premier sponsor of the UNSW Law Journal. This is the 39th year of sponsoring since the law school was founded back in 1971. As an alumnus of UNSW, it's really nice to be able to assist in the launch of this journal. And although I was not part of the journal during my time at law school, there was then and there is now full appreciation of the value of the UNSW Law Journal, and in fact all of the journals from all of the different law schools. The valuable contribution that each of those can make to the broader dialogue of the current issues in the legal community and our community more broadly. Alan's relationship with UNSW is extensive. Among other initiatives, we're extremely proud of the Alan's Hub for Technology, Law and Innovation that we've been supporting for more than 3 years. Over that time, there's been 41 hub members, 44 projects, 181 publications, 23 submissions to government, parliamentary inquiries, law reform and projects amongst others. I'm not telling you anything you don't know, that this year has been special and it's a shame that we can't hold this in person. But we've all adapted to this new world, and being able to deliver this launch virtually together is something that we and Alan's are very happy to assist with. And with that now I'll hand over to Chan, editor of issue 43.4 of the UNSW Law Journal, to speak. Thank you.
Thank you very much for that, Tim. Before I begin, I too would like to acknowledge the traditional custodians of the land upon which we meet, the Gadigal peoples of the Eora Nation, land on which was occupied and never ceded. I would like to extend my respect to elders past, present and emerging, and to any Aboriginal and Torres Strait Islander peoples joining us for this occasion. Thank you all, whether physically present or dialing in digitally, for attending this launch of Volume 43, Issue 4 of the University of New South Wales Law Journal, the last such publication launch of the 2020 calendar year. While there were high hopes that this launch would be able to be conducted in the normal fashion, it is clear that the country is still dealing with the ongoing effects of the pandemic, and we must spare a thought particularly for our fellow Australians down south in Victoria, who I wish all the best at this time. For those of you who have joined us for previous launches, it will come as no surprise that we will begin with dispensing thanks to our contributors, editors, patrons and all others that have made the ongoing publication of the journal possible for all these decades, let alone the publication of the comprehensive issue 43.4 for this year. Although it is now a rather old hat to emphasise the entirely voluntary student-run contributions of the editorial board, noting the emergence of many fine law reviews who have adopted this same approach, I would be remiss to not applaud the model itself and the fine aptitude of our student editors that are on the current board. You're all wonderful editors, and I note the exceptional circumstances in which you all had to contribute to the publication of this issue. I, on behalf of the Executive Committee, are grateful to you for all your contributions and hard work this year. Thank you to the authors of the articles in this issue. I hope that this launch and the receipt of the bound copy of the journal will be of some gratification to you all tonight, capping off an extended year of peer review and editing. Thank you all for your immense patience and forbearance throughout the whole process, and for wholeheartedly taking on board the suggestions, big or small, of our anonymous peer reviewers, who I also sincerely thank for their unremunerated time and effort. I am grateful to have worked with you all and to have had a front row seat to the formulation of some of the newest and most high quality legal scholarship in Australia. Thank you to our institutional patrons and supporters from the UNSW Law faculty. It is a privilege to be able to use a lion on the cross of St. George in our masthead, and we hope that the publication continues to be an enduring fixture of the law school. I thank in particular our faculty advisors, Professors Roslyn Dixon and Gary Edmund, who were instrumental in providing guidance on many of our transitional processes this year, many of which were referable to the pandemic. I thank our deans over the past year, Professor George Williams, now Deputy Vice-Chancellor, Planning and Assurance at UNSW, and Acting Dean, Professor Andrew Lynch, for vouching for the board and for believing in the value proposition of the journal. I now retreat to a refrain that has become somewhat notorious amongst the Executive Committee. It takes a village to raise an issue. I thank Veronica Sebesky, current digital editor, for coining this phrase in 2018, and in addition warmly thank both Antonia Zhu, current executive editor, and Sarah Phillipson, forum editor, for all your support. Your administrative help and fonts of institutional knowledge have not gone unnoticed. This also applies to the issue editors for this year, Phoebe Saxon, Tom Milner, and Inderpreet Singh. Your patience and willingness to answer questions at rather unreasonable hours of the night is very much appreciated. Finally, I would like to thank our premier sponsor, Allens, for hosting the launch and for having provided the AV facilities and ongoing support to make this event a success in this climate. It is often the case that a general issue, in contradistinction to a thematic, presents itself as a grab bag of topical legal issues. And I think this is a great strength in the context of a journal's dual thematic and general publication structure. The UNSW Law Journal isn't a trade or specialist publication. It is one intended to reach a broadened audience of practitioners, academics, and students as possible. And it is in this diversity that the journal has found its enduring attraction and prestige. I'm particularly excited to introduce you this issue 4, containing an outsized 16 articles on various legal topics. These include, among others, intersection or lack thereof between investment treaty law and constitutional law, the differential treatment of migrants under criminal law in Australia, empirical surveys and studies of the corporate world, including investigatory powers and internal trading policies of ASX 100 companies, and gender equality amongst legal practitioners, and even the complex electoral issue of filling a casual vacancy. I'm glad that this final issue for the year is able to be launched with so many articles, not least because the cover will be rather salient to everyone's bookshelves. I'm ultimately confident that this will be yet another fine addition to the journal's history of scholarly contributions. I now turn to the keynote address for the launch. We are honoured to have the Honourable Justice David Hammerschlag joining us tonight to provide the opening remarks for the general issue. Prior to his appointment to the New South Wales Supreme Court in 2007, Justice Hammerschlag had a diverse and distinguished legal career in South Africa, including as a solicitor and partner at a major commercial law firm, and also as a military lawyer in the South African Defence Force, before being called to the South African Bar in 1982. Upon moving to Australia in 1986 and requalifying not long after, His Honour maintained a thriving practice at the New South Wales Bar. Justice Hammerschlag now administers the commercial arbitration, and technology and construction lists of the Supreme Court in the Equity Division, and has also sat on the Court of Appeal and the Court of Criminal Appeal. It is my pleasure to hand over to Justice Hammerschlag and invite him to provide the keynote address for this launch.
It's my privilege and a pleasure to give this keynote address on the launch of issue 43.4 of the UNSW Law Journal 2020. The journal produces high-quality, scholarly, interesting and topical articles, and this edition is no exception. The editor, Sung Chan Ree, the editorial board and the contributors deserve congratulations. The launch theme is the alien and the law, but the specific topic that I've been asked to address, or rather which has been assigned to me, is: has the law, in the context of the legal profession or society generally, over time shifted so as to give greater weight to mediating between outsider and insider groups, or rather putting up barriers to admission of aliens to the establishment? No doubt a thought-provoking topic, but an examination of weight shifts in the law, either towards or against mediating between outsider and insider groups, or of lifting or lowering barriers in general society to aliens, would be more appropriate for a lifetime occupying doctoral thesis than this brief address. It would require consideration of definitional questions such as what is meant by society, outsider and insider groups, barriers, establishment and even aliens. More importantly, I don't feel qualified to perform that examination. However, when it comes to barriers to admission to professional practice, I do have a little knowledge and experience, which perhaps qualifies me, at least in part, to say something about that. In 1985, the requirements for practitioners from South Africa for admission to practice law in New South Wales were passes in 2 or 3 subjects, the examinations being conducted by the Solicitors Admission Board and taught by the Law Extension Committee. The staple requirements were Australian constitutional law and real property, both understandable. For practitioners not of long standing, ethics too was required. In 1986, when I was fortunate enough to immigrate to Australia, an alien invasion of South African lawyers was then anticipated and, more importantly, feared, and the requirements for admission were sharply raised. Passes in 7 or 8 examinations, including subjects that were elective to local lawyers, such as family law, conveyancing and tax, were now required. This was no doubt a raising of the barrier. I shaped up for a fight, but by the time the fight was ready to be had, I had passed, albeit not that very well, 7 examinations. I have personal reminiscences, good and bad, of those times, but this address is perhaps not the occasion to indulge in them. It may well be that the pendulum has swung a little in the other direction since 1986, after those decision makers moved on. I too moved on. But perhaps it was karma that later some of the lecturers in the courses which I had sat and passed appeared as my junior. In 1998, when I first applied, unsuccessfully I had, for Silk, a member of the committee deciding the applications told me that my application was premature because my overseas experience was irrelevant. Maybe he was right. That barrier came down for me in 2000. Perhaps the true description of this address is an alien in the law. Shifts in either direction in barriers to admission to arenas of different types are no doubt often attributable to shifts in the attitudes of those who are applying the rules, especially where discretions are involved, rather than to shifts in the rules themselves. Sentiment, sometimes positive and sometimes negative, no doubt often plays a part, but sentiment is intrinsically transient. For this reason, at least, shifts are never permanent, and a shift in one direction seems often not to keep going for very long, and certainly not permanently. Perhaps a good starting point for a discussion such as the present is who exactly is an alien or an outsider. This is a significant topic on its own. The legal concept of an alien is like every other legal concept, just a human construct. In the 18th century, in Daubeny and Davalon, MacDonald C.B. said that the word alien is a legal term. It implies being born out of the legions of the king and within the legions of some other state. This is a narrow view, and in relative terms, a very recent one. At about that time in England, various statutory disabilities by which aliens were incapacitated from the possession of property were mitigated, and they were enabled to acquire nearly the full rights of natural-born subjects, with the exception of eligibility to become a member of the Privy Council of either House of Parliament or of a municipal corporation. These and other barriers have since been lowered. But there are aliens and outsiders of varying types. Recently, in Love and the Commonwealth, the High Court determined that Aboriginal Australians are not within the reach of the aliens' power conferred by Section 51(19) of the Constitution. It might have come as a profound surprise to an Indigenous Australian with thousands of years of ancestry on this continent that she or he might, for any purpose, be considered an alien under the law of the land. The shifting nature of the concept is disclosed by the statement by the Chief Justice, who observed at 49 that for a short time it was accepted that there was a special constitutional category of non-citizen, non-alien. Until 1989, when the High Court in Street and the Queensland Bar Association corrected the position, non-residents of Queensland were barred admission to practice law in that state. One such non-resident was Mr. Alexander Whistler Street. Now he's on a Judge Street of the Federal Circuit Court, hardly an alien, but nevertheless barred from practice in Queensland. Here, Section 117 of the Constitution, which provides that a subject of the Queen resident in any state shall not be subject in any other state to any disability or discrimination which would not be equally applicable to him if he were a subject of the Queen resident in such other state, provided the mechanism to strike down the Queensland entry barrier. Let us also not overlook Section 1 of Article 2 of the Constitution of the United States of America, which provides that no person except a natural-born citizen or a citizen of the United States at the time of the adoption of the Constitution shall be eligible to the office of President. No lowering of the natural-born barrier appears to be on the horizon. Not many people who were citizens or aliens at the time of the adoption of the US Constitution, however, are presently affected. The legal concept and different treatment of the alien, however, is far more ancient than this. The ancient Greeks had a highly developed concept of the metic, a foreign resident of Athens who did not have rights of citizen in the city-state. It is said that at the commencement of the Peloponnesian War in 430 BC, metics accounted for about 1/3 of the population of Athens. They held lower social status, although not necessarily economic status, a phenomenon still current with aliens in many places today. Irrespective of how long a family had lived in Athens, metics did not acquire citizenship unless it was gifted to them, and this was rare. There were limitations on their owning land, and they were taxed differently. They could not serve as jurors, but did have access to the courts. By and large, they were attracted to Athens by opportunities not available to them in their place of origin. Over time, their distinctive status dissipated, and by the 4th century BC had dissipated in Athens. One can go back even further to biblical times, but for this address, I will resist that temptation. A decision concerning barriers to medical practice, a matter which is referred to in the editorial to this edition, in which I had more than a passing interest because I appeared in it, is Shakinovsky and the Dental Board of New South Wales, 1999 30 Administrative Reports 430. Dr. Shakinovsky was a highly experienced oral and maxillofacial surgeon who had practiced in London, South Africa, and Israel. He was the author of many publications and had presented many papers at scientific meetings. He immigrated to Australia in 1997 and obtained registration as a dentist and then direct registration as an oral and maxillofacial surgeon in Western Australia and Victoria. The Dental Board of New South Wales gave him registration as an oral surgeon, but would not give him registration as an oral and maxillofacial surgeon, which had ramifications, including with respect to the rebates that were chargeable for services performed by Dr. Shakinovsky. The Dental Board of New South Wales, relatively for present purposes, took advice from a panel. At least one of the members of the panel called into question Dr. Shakinovsky's foreign experience and took the view, which prevailed at the board, that he should be denied registration unless he sat further examinations. The doctor challenged the decision. He relied on the Mutual Recognition Act, 1992, Commonwealth, which contains provisions for registration to practice a profession in a state or territory based on registration in another state or territory. Dr. Shakinovsky's challenge was upheld. The deputy president of the tribunal considered that there was no evidence that Dr. Shakinovsky's skills and experience were other than at the highest level. Once again, the law was the vehicle to bring down a barrier wrongly constructed by those given discretion on a matter of a barrier. It is perhaps apt to conclude with reference to a different kind of alien. Spock, played by Leonard Nimoy in Star Trek, himself an alien, greeted other aliens with the words, "Live long and prosper." This was accompanied by a hand gesture, which Nimoy copied from the Aaronic high priest blessing, which is thousands of years old. I offer the same salutation to aliens or otherwise who might intentionally or unintentionally hear this address.
My name is Roslyn Dixon. I'm a Professor of Law at UNSW Sydney and one of the faculty advisors to the UNSW Law Journal. I want to begin by offering my very sincere congratulations to the editors of this wonderful new edition of the Law Journal on Aliens and the Law. All of the students involved have worked tirelessly to produce it and bring it to fruition. They are so careful in the work they do in selecting and curating pieces for the journal based on the peer review and advice of experts. And then they do an amazing job of ensuring the accuracy of all the citations and all of the prose in the journal. And you'll see the wonderful professionalism and final product on display here this evening. The journal is one of the things that the faculty is most proud of. It reflects our traditions of research excellence, our concern for addressing questions of real-world significance and impact, and working very closely with students to produce the kind of work that we aspire to do. And as you may know, the Law Journal is a fully student-led and run journal that only turns to people like myself and Professor Gary Edmond for advice and guidance, and we do not make the ultimate decisions on anything that appears in its pages. So it's in the best traditions of UNSW law, research excellence, real-world relevance, and student faculty collaboration that the journal produces an edition and a journal of this quality. I want to note how hard it's been during the pandemic for the students to continue their ordinary workload, to juggle the challenges of working from home in producing something like this, the stresses of worrying about family and friends and their own personal circumstances, and transitioning to online learning while doing all of this work. And it's a testament to their resilience and determination and professionalism that they've managed to do so, and do so successfully. My final job is to offer a vote of thanks, and that goes not only to our students, of course, and to their hard work, but to our wonderful hosts for this virtual launch, Allens, and particularly the partner who has spoken and hosted the event virtually on their behalf, Mr. Tim Stewart. Allens is a long-time friend of the law faculty through the work of the Allens Law and Technology Hub, and of course through their long-standing support of the Law Journal. You recruit some of our best students. We are very proud of our connection between UNSW and Allens, and this is just one small part of that broader relationship that we're so grateful for and proud of. Thanks to all of you who've joined this evening online to see the fruits of this wonderful work, and the authors who contributed their terrific research and ideas and trusted it to the Law Journal to produce and publish. It is a magnificent discussion. It's a very timely one to think about, as Justice Hammerschlag said, the divide between the insider and the outsider and what alienage means. And my final thanks is to Justice Hammerschlag to say thank you for spending your time reading and thinking through the relevant articles so thoughtfully and carefully, and for being so generous as to lend your remarks virtually again this evening to make this launch so special and successful. My thanks and good evening.
Thank you very much, Professor Dixon, for those kind words of support, and thank you all to the viewers at home for tuning in tonight. Chan will now introduce the authors participating in the Q&A session. We hope that you enjoy these conversations and insights into their articles.
Thank you very much, Antonia. Turning now to the author Q&A component of the evening, we will now seek insight from three of our authors in this issue 43.4. They will talk about the substance of their articles and give us a brief introduction to what we can expect as readers, and furthermore, give us an outlay of how their articles relate substantially to the theme of this evening as well, the alien and the law. Joining us today, we have Mr. Chris Draffen, law graduate at Baker McKenzie, who will speak on behalf of both himself and Dr. Yi-Fui Ng, senior lecturer from Monash University, as co-authors of the issue 43.4 article, Foreign Agent Registration Schemes in Australia and the United States, the Scope, Risks and Limitations of Transparency. Thank you so much for joining us today, Mr. Draffen.
Thanks for having me.
First of all, could you just give us an introduction to the article?
Yeah, of course. So in 2018, Australia passed an act called the Foreign Influence Transparency Scheme Act, which in effect creates a mandatory public register for people who are, I guess, seeking to influence domestic politics on behalf of a foreign principal. And so what our article does is two things. Firstly, the Act is really heavily based on a similar American statute, which was first introduced in the 1930s, which provides Australia with some really good lessons, not all of which were heeded in drafting our Act. So the article firstly contains, I guess, a fine-grained comparison of the Australian Act with the US Act. Secondly, and probably more importantly, the overarching question that we really sought to answer is that although in public discourse, the transparency aims of an act like this are really questioned. And what I mean by that is by politicians, is that foreign agent registration schemes that have been enacted around the world have been shown in certain circumstances to have a chilling effect on debate sometimes, and also a disproportionate effect on actors with fewer resources. So we wanted to apply that understanding to the Australian Act to see how it fares in that respect.
And I think it's great that this comparative analysis is being undertaken, particularly when I think now legislators take so many cues from almost what foreign governments and comparative foreign governments are doing today. But also, I think this article canvasses the issue of the mediation of insider groups with outsider groups, or so-called aliens. How do you think your article explores this issue then?
Yeah, that's a really good question. I think the article explores this issue really directly, in that I guess the statute that we examined is a real direct attempt by the Australian government to regulate foreign influence on domestic politics. And so I guess on one hand, in terms of mediating insider groups with outsider groups, it's potentially not even really that the statute tries to mediate insiders and outsiders, but conversely, I think it's more of a way of, the insider, that being the Australian government, trying to control the outsider in this situation.
Absolutely, and I think that analysis comes through in your recommendations for what different approaches or perspectives could be adopted with respect to the legislative scheme. So then ultimately, what do you think we can learn about the way policymakers, governments, and even NGOs approach this issue of relations with foreign third parties, or perceived fifth columns?
Yeah, it's interesting that you mentioned the perceived fifth column, because the American statute that we explore in our article was originally enacted in the 1930s as a way of regulating foreign propaganda, obviously with the threat of war being quite close then. But the Americans did amend their act to be more targeted towards foreign lobbyists in the 1960s, and the Australian Act today aligns more with those amendments. Look, ultimately, I think our article being an analysis of quite a specific act, one thing that we can learn about the way that policymakers approach foreign relations is that creating a public register for lobbyists with foreign links is one method of regulating foreign influence on our politics. It is a method that has risks, and some of those risks remain in the Australian Act.
In terms of the historical parallels that are brought up with the US Act as well, are there any particular historical parallels you noticed in the course of research looking at the Australian Act?
Well, as I was saying, the American Act was amended in the 60s to be more targeted to what was, I guess, a more modern form of propaganda, which was lobbying by foreign governments, or even just people with foreign links to the American government. And as I was saying, the Australian Act aligns more with those amendments today, in that it tries to regulate people with foreign links trying to influence our domestic politics. So yeah, they're probably the main ways that they align in our article.
It's very interesting, I think, as an observation then, particularly looking at, I suppose, a lot of the different contexts that the US government has had to deal with, and the fact that Australia is in many respects aligning itself in a little way with the way it's been adopted in the United States. So then, what would be one key takeaway you would like readers to come away with having read the article?
Yeah, I think probably the one biggest takeaway is that I guess the transparency aims of a law like this, or such as the Foreign Influence Transparency Scheme Act, often lead some people to try and quash any debate about whether something like this is necessary. And what I mean by that is politicians, because they don't want to be seen as saying that they are against transparency. It's rarely questioned as a norm in our politics. And that's obviously been shown to be quite important recently with things such as ICAC in New South Wales. But once you try to look past this rarely questioned norm of transparency, it is important to be able to critique a law like this, because a law like this does have the potential to pose some really unintended or consequences that aren't stated by policymakers. So I think at the very least, it's a really good reminder of that.
Certainly a theme that's becoming more and more prevalent and more topical as the days progress. Well then, thank you again for joining us, Mr. Draffen, and my thanks also extend to Dr. N for a contribution to the article as well. Thank you so much.
Yeah, thanks very much for having me, and really appreciate it.
Joining us today, we have Associate Professor Gabriel Wolf from the Deakin University School of Law, who will be speaking on issue 43.4 article, The Law and Politics of Registering Doctors, Lessons from New South Wales, 1937 to 42. Thank you so much for joining us today, Gabriel.
My pleasure.
First off, could you kind of give us an introduction to what the article is about?
Yeah, sure. So my article examines responses to doctors who fled Europe and in the 1930s and 1940s and came to New South Wales and sought to practice there and get registration to practice. And despite the fact that there were very few of these doctors and really irrespective of their skills and experience, many of them failed to secure registration to practice. And my article looks at how this was largely due to the efforts of members of parliament who collaborated with doctors who registered, represented and educated the medical profession, who were very keen on preventing these doctors from practicing. So they were doctors who were members of the New South Wales Medical Board, which was the statutory authority that was vested with power to register doctors, members of the British Medical Association, which was the precursor to today's Australian Medical Association, and many of the members of that peak body were crossover members of the medical board, and also the University of Sydney's medical faculty as well. So they were really keen to prevent these doctors from practicing. And I look at evidence that suggests that this was largely due to protectionism, but also prejudice. And the article analyses aspects of the legal regime that was governing registration of doctors at that time and that permitted those factors to influence really decision making about registration applications from these doctors. And then I look at cautionary lessons that we might learn from this history so that overseas trained doctors who are granted asylum in Australia, provided they are safe and competent to practice, are permitted to do so.
Excellent overview. And I think that's quite an interesting look at the history of what's happened in our really not so distant past. And I think that relates particularly to the theme then, in that the law can often be a source of and also solution to the situation of discrimination. And this might particularly be the case for outsider groups that we might term alien. So how do you think your article really explores this issue or connects with it?
So my article really delves into how the law was used to discriminate against these European doctors who were very much constructed as outsiders. And in fact, they were called alien doctors and also refugee doctors and foreign doctors, but the term was used really as an exclusionary sort of term. And I think I can give a couple of examples that illustrate that sort of discrimination. So I look at the period between 1937 and 1942, which was really the peak time when the medical board was receiving applications from these doctors to practice. And at the beginning of that period, basically the medical board was permitted to register doctors who had registration from the General Medical Council in the United Kingdom. And they could get that registration if they had what was called the triple qualification, which was a qualification earned after a year of postgraduate clinical study by the Scottish Triple Qualification Boards. So they could get registration here. They were eligible for it on the basis of that. So basically what the board did, it was, as I said, stacked with these British Medical Association representatives, lobbied the government to change the legislation to preclude these doctors' eligibility for registration on the basis of this triple qualification. And they succeeded. And there were members of parliament who were very sympathetic to their entreaties, and they changed the legislation to confine the board to registering annually just 8 doctors who they called who are not natural born British subjects. Another example of discrimination perpetuated by the university was that there's another path to perpetrated, I should say, by the university, was that there was another path to registration which was open to European doctors who had trained in a country outside the British Empire that had what was called reciprocity with New South Wales, which meant that doctors who were registered in New South Wales by virtue of that registration could practice in that other country and vice versa. But on top of that, they also had to have completed and passed the final 3 years of Sydney University's medical course. So what the university did was, and the dean of the medical faculty at that time, and also the Senate of the university were opposed to admitting too many of these foreign doctors. So the faculty said, we're not going to admit, this was in 1942, said we're not going to admit more than 12 of these doctors annually to the course. And the other discriminatory thing that they did was, once these doctors had completed, if they were allowed to complete the final 3 years of the course, they granted them only a certificate and not a degree. And the significance of that was, it meant that without a degree, they couldn't then apply for registration under another provision of the legislation that governed regulation of health practitioner doctors at the time, which basically had no cap on the amount of doctors who had Australian degrees. So basically they were in cahoots, limiting the number of these doctors who could be registered. So yeah, my article also looks, as you mentioned, at possible safeguards against a repetition of this past discrimination that have been instituted since that time that might prevent the same discrimination happening against overseas trained doctors who are granted asylum in Australia.
I think that's a very interesting approach, Associate Professor Wolf, particularly so since that although the themes of this article are really quite rooted in history, noting some of the citations and newspaper headlines and even the headings in the letters, these kinds of attitudes and these kinds of approaches seem to repeat in cycles throughout every single wave of policy change and changes in the law. And ultimately, what lessons do you think we could draw from the attitudes of the medical establishment in interbellum and wartime periods, and how prescient do you think they are to our current day context?
Yeah, so look, I would agree with everything you've said, and I think that what my article looks at is how protectionism and prejudice can lead to the preclusion of competent overseas trained doctors from practicing if the legal regime that's governing the registration and regulation of doctors allows them to prevail. So for instance, you know, if whether an overseas trained doctor obtains registration is contingent on Australia's relations with the country in which they trained, if advocates for the profession are permitted to be representatives on the registration authority, but also not just that, but also if they are allowed to, in making registration decisions, base them on factors other than competence and safety to practice and to provide medical services to meet demand for that. And importantly, if there's no legal impediment to them discriminating and no remedies against this kind of discrimination. And I think as I talk about in this article, that this history does remain very relevant today. We have this humanitarian crisis with so many asylum seekers around the globe. Australia's approach to asylum seekers has very much polarised public opinion, and there have been calls to lower the number of overseas trained doctors who are permitted to enter Australia and practice here. And in the recent past, there was a debate about whether registration and accreditation processes discriminated against overseas trained doctors. The Medical Board has addressed those issues, but it's not so long ago that was the case. But as I mentioned, my article does look at changes to the law since that time that might operate to prevent that kind of discrimination. So for instance, what's interesting is that as the time has progressed since the 1930s, more and more lay people are permitted to be members of that registration authority. And we've had a move since 2010 from a state-based registration system to a national registration system for health practitioners, including doctors, and that might insulate to some extent the influence of lobby groups over the registration decision making. Now, for instance, overseas trained doctors don't have to enrol in an Australian medical course before they've had an evaluation of their skills and qualifications and experience, and that can actually be conducted independently of the registration authority, which, as I mentioned, is the Medical Board of Australia now. And that medical board doesn't have to take in these arbitrary matters like what Australia's relationship is with the country in which a doctor trained. And especially important, of course, are anti-discrimination laws, particularly since the 70s, that prohibit discrimination in work context, so qualifications and authorisation to practice a profession.
Absolutely, and those kinds of structural barriers are certainly deserving of thorough analysis and, I suppose, again, a rigorous re-examination in the circumstances. As an advertiser for our readers then, although we've canvassed numerous issues and numerous important parts from the article, what would be one key takeaway you would like our readers to come away with having read the article?
So I would say sort of, I suppose, two, if I might, points. The first is that I really think there are very compelling reasons, which are moral, economic and public health reasons, to permit doctors who are granted asylum in Australia permission to practice if they're able to do so competently and safely. It's ethically responsible to give people who have fled from persecution opportunities to start a new life, and also they can support themselves by working and deliver really valuable community services, including to fellow immigrants who have come here. So a really important opportunity for them to provide that service. And my second point was about that I think that the primary determinant of whether they're able to provide medical services here is whether they can do so competently and safely, and an assurance that that's the case.
On that note, thank you so much for joining us, Associate Professor Wolf.
My pleasure. Thank you for having me.
Certainly our readers will very much appreciate your insight into the subject matter of the article.
Thanks so much.
Joining us today, we have the Honourable Justice Nicola Payne, Judge of the Land and Environment Court of New South Wales, co-author, alongside Ms Georgia Pick, of the Issue 43.4 article, Balancing Competing Interests in the Criminal Justice System, Aboriginal Fishing Rights in Coastal New South Wales. Thank you so much for joining us today, Your Honour.
My pleasure.
Could you kindly give us an introduction to what the article is about, first of all?
Certainly. I suppose I have a long-standing interest in the way that the criminal law operates in all aspects of environmental protection. A very wide area indeed is covered by environmental criminal law, and that does in fact include fisheries management law. And it's frankly not an area that I've ever had to actually give a decision in, because a lot of the judgments we talk about in the article in fact happen in the local courts of New South Wales. But broadly, I have an interest in how things such as Aboriginal cultural fishing might be impacted, as did Georgia Pick, my co-author, in the context of criminal law. So under the Fisheries Management Act of New South Wales, Aboriginal fishers, as anybody else, can be charged with breaches of the fisheries laws. Particular areas are things like having too many fish in the catch. Particular area also is abalone, for example, and exceeding the quotas permissible for abalone. So in the local court in New South Wales, there has actually been, over a number of years now, quite a lot of prosecutions. So I suppose, as is clear from the title, we were asking, is the balance right between enforcing the criminal law aspects, which really are about preserving a biodiversity and fisheries resource, with Aboriginal people in the pursuing their cultural fishing traditions, which are also very strong. And a particular area of focus was the southern coast of New South Wales, because there in fact has been a lot of controversy in that area, and actually quite a few prosecutions in that area. So that was what we were asking about. The article looks at the importance of fishing to Aboriginal people from a cultural perspective, looks at the way the Fishery Management Act does work. Interestingly, there is a section of that Act that was actually created in 2009 that does recognise Aboriginal fishing, but in fact it's never commenced. It was unclear to us. We couldn't find out quite why that is. And certainly we conclude at the end of the paper it would be very useful in terms of getting this balance right to have that section, that happens to be section 21, capital A, actually made as to be given effect. It's been passed, but it's not commenced. We also look at native title. I'm sure probably quite a lot of readers are well aware that native title had quite a substantial impact on state and territory resource management laws in the area of Aboriginal cultural traditions and heritage. And there is, by virtue of the Native Title Act Commonwealth, a native title defence to criminal prosecutions under state law. And we do look at quite a few cases, but it does seem that proving native title when you haven't got actually a formal declaration of native title has proved difficult for Aboriginal defendants. And most of the time, certainly in New South Wales cases, they have not been able to successfully rely on the native title defence, which they have to establish on the balance of probabilities. And so the cases seem to suggest that just general evidence about broadly Aboriginal practice won't get you there. You do have to absolutely have evidence that addresses the particular facts of the case, which seems, from a judge's perspective, entirely reasonable, but also that can be quite difficult for Aboriginal defendants to do. Some of those cases have taken many, many days, if not weeks, in the local court. There's one example in the local court in New South Wales that went for many, many days. And that is, frankly, a somewhat unusual situation for the local court. So we look at a few cases around Australia. There are other jurisdictions that do formally recognise cultural fishing in the State and Territory Act, and there are some cases where that's been successfully relied on, and we do think that's a good model, and hence one of the recommendations being having Section 21 of Capital A of the Fisheries Management Act implemented. And then we discuss, I suppose, some of the policy objectives, perhaps in the exercise of prosecutorial discretion by the relevant department in New South Wales who's prosecuting. And we also recognise, in fact, more recently in the local courts, say in the last 4 to 5 years, there has actually been greater recognition by the department of the need to recognise cultural heritage needs of Aboriginal people, and that has been reflected in some changes in prosecution policy. So at the end, we conclude, as I've already said, we think this Act needs to be coming to place with this section being implemented, and we do think more explicit provisions in the prosecutorial policy of the department to really reflect what seems to already been happening in practice would provide a better package in terms of balancing the two interests.
Thank you very much for that comprehensive overview, Your Honour. It's interesting that you mentioned balance in the article, and I do think it's a recurring theme throughout the substance of the article. The law seems to frequently be in a role where it has to mediate between competing interests. And to what extent do you think this mediating function has been exercised successfully in the context of Aboriginal fishing rights?
Look, it's a mixed bag in New South Wales. I think one of the things we conclude on in the article right at the end is there are two actually major native title claims over coastal areas of New South Wales. So if those are successful, there will be very large areas of the coast that are subject to native title. That might well make it easier to rely on the native title defence in the state court, often the local court. But also, I think if, obviously, as I've said a couple of times now, if the Act itself better recognises Aboriginal cultural fishing, that would be of benefit in achieving the balance better, and does reflect essentially what's happened, particularly in Queensland and Northern Territory, have similar provisions in force, and that seems to have resulted in, I think, a reasonably balanced approach to what is a difficult area. There's no doubt about that.
So I believe you already alluded to this in your comprehensive responses before. So do you think that the issues explored in the articles indicate a greater need for recognition of the cultural rights of Aboriginal communities in the context of fishing rights? Is that correct?
Yeah, I think it should be more explicit than it is. I think it's happening behind the scenes, and I think there are changes in prosecutorial discretion being exercised that are for the good, but I think it's the black letter law bias is to have it made very explicit.
So ultimately, do you think this is a question of legal enforcement or of an amendment to the law more so than policy? and the way the law has been constructed?
I think it's both, because this applies in all areas of criminal law. The exercise of prosecutorial discretion is so key as to who gets prosecuted and how and where. So you do need a prosecutor to understand and consider how they should exercise what is a very onerous impact on somebody. To be charged with a criminal offence is extremely onerous and has major consequences for people. So you need to have that understanding by the prosecutor of what the overall aim is, what the interests being balanced are, as well as explicit provisions in acts, obviously, which clearly guide the courts who are considering it in how they are going to exercise their approach on a criminal matter.
Well, thank you for that broad overview, Your Honour, and I'm sure that our readers are eagerly awaiting the publication of the article such that they can have a read for it themselves. And my sincere thanks to both yourself and Miss Georgia Pick for your contributions to the journal as well. Thank you for joining us.
Thank you very much for the opportunity.